London, one of Rolf Harris' child sex convictions has been quashed on appeal, because a key witness at his trial was later discovered to be a fantasist who had invented an implausible tour of duty in Korea. The English Court of Appeal, however, denied the 87-year-old Australian former entertainer the right to appeal his other 11 convictions. The court delivered its judgment on Thursday morning, London time. Harris did not attend court. Lord Justice Treacy agreed with prosecutors that it would not be in the public interest to retry the quashed conviction, that Harris groped an 8-year-old girl at a community centre near Portsmouth in the late 1960s. Lord Treacy in the court's written judgment said, however, that there was nothing that causes us to doubt the safety of the other 11 convictions. Harris was convicted in June 2014 on 12 counts of indecent assault against 4 women, who were aged between 8 and 19 at the time of the attacks. He was sentenced to 5 years and 9 months in jail. Harris left prison in May this year. Get the latest news and updates emailed straight to your inbox. By submitting your email, you are agreeing to Fairfax Media's terms and conditions and privacy policy. His lawyers had told the court earlier this month that fresh evidence meant convictions on 4 counts, against 2 of the women, were unsafe. The other convictions should be reversed as well, they argued, as the jury had considered Harris' entire alleged history of sexual abuse when considering each charge. Stephen Bulow, QC, for Harris, said the fresh evidence, compiled by a long, expensive and painstaking investigation by private investigators, was credible, it's reliable, it goes to the central issue in the case and it was raised at the trial. The testimony of the father of the 8-year-old's alleged victim, and 2 ex-police officers, made it blindingly obvious that Harris had never been at the community centre where his victim had said he groped her, Mr. Bulow argued. Lord Treacy dismissed much of the fresh evidence, including that of the father, as insignificant or unreliable. By far the most cogent fresh evidence before the court, he wrote, was that relating to David James, the only person other than the alleged victim to confirm that Harris visited the community centre. It was an oddity that no one had picked up a reference by Mr. James to being on leave from a tour of duty in Korea at the time, though the war had ended a decade and a half earlier, Lord Treacy said in the written judgment. For some reason, at the time of trial the necessary checks, of the witness background, had not been made or had not properly been made, he said. This was a significant failing. If the material had been obtained and disclosed at the correct time, it is very doubtful that Mr. James would have been called as a witness. The exposure of the truth about his military service and employment history would have been of great significance. Mr. James was a very important witness. Mr. Bulow also argued the jury had not seen medical evidence about another of Harris' victims, which showed she had told counsellors about her abuse by a family member almost 50 times without mentioning Harris. She later said Harris had groped her repeatedly in a London pub when she was 15.